Welcome, everyone. Thank you for joining us for today's event, is Popular Rights, a debate on popular constitutionalism and judicial review. I'm Kara Stein. I'm the Director of Programs for the American Constitution Society. For those of you who are not familiar with ACS, we are a national network of lawyers, law students, judges, and policymakers who believe the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues. We're delighted to co-host this event with our UC Irvine student chapter and our Orange County lawyer chapter. And I'd like to recognize our chapter leaders, so anyone who's interested in getting involved can talk with them after the program. So student chapter leaders, where are you? I know you're here. Yes, hi. And lawyer chapter leaders, Dan Cornelius and Neela Galyar are here. So feel free to chat with them after the program. Today's discussion is the second in a series of programs ACS is holding this spring that we're calling intra-progressive debates. These are conversations intended to identify common ground through exploration of the fault lines within the progressive community on important topics of the day. And to get us started, it's my great pleasure to introduce our moderator, a good friend to ACS. Rebecca Latham-Brown is a nationally recognized constitutional law theorist who is the Newton Professor of Constitutional Law at USC Law. Before entering academia, Rebecca clerked for U.S. Supreme Court Justice Thurgood Marshall and U.S. Court of Appeals Chief Judge Spotswood W. Robinson III. Professor Brown also worked in the Office of Legal Counsel in the U.S. Department of Justice and practiced with Onek, Klein, and Farr in Washington, D.C. Her scholarship focuses on judicial review and its relationship to individual liberty under the U.S. Constitution. Of course, this makes her the perfect moderator for today's discussion. Please join me in welcoming Rebecca Brown.
Thank you so much to all of you and Kara for organizing this wonderful event. I'm especially thrilled to be able to facilitate this important conversation between these two experts for the evening, because both people that are flanking me right now are old and dear friends as well as admired colleagues. So you have programs, I think, with their complete resumes. If we really wanted to do justice to their careers, we wouldn't hear anything else tonight. So I don't want to spend too much time. I just want to briefly introduce Dean Chemerinsky probably doesn't need much of an introduction for this audience. Founding Dean and Distinguished Professor of Law here at the University of California, Irvine School of Law. He's written countless books and articles that I'm not even going to try to enumerate. But I think what Erwin is most known for is affecting the law and the policies in our country in many different ways, including his teaching and his scholarship, but also including arguing important cases in front of the highest courts of the land, as well as placing himself in the public eye on a repeated basis, talking about important issues of the day, and by performing an amazing amount of law-related public service. So you have in your dean both a great scholar and an outstanding public intellectual. So he will be one of our panels. The other is another dean. Larry Kramer is the dean, and Richard E. Lang, professor of law at Stanford Law School. And he's been doing lots of dean magic at Stanford, but he also has done something that's very difficult to do, which is to maintain a scholarly reputation and keep doing very important work on the subjects of federal courts and their role in our democracy generally. He clerked for the legendary Judge Henry Friendly of the Second Circuit and for Justice William Brennan on the U.S. Supreme Court. So I had the honor of occupying the office next door to Larry's when he was clerking for Justice Brennan. And I noticed that during our clerkship year, the more I became enamored of the Supreme Court, the more Larry drifted towards cynicism about it. So I think both of our career paths have been shaped by that experience, as we will see tonight. We're going to talk tonight about the role of the people and the judiciary in implementing our Constitution. Just a week ago, as everyone knows, 3 days of oral argument in front of the Supreme Court on a constitutional question spawned an amazing, extraordinary amount of commentary and discussion and speculation in the popular press. And so the relationship of the American people to our Constitution could not possibly be a topic that is more salient at this moment in our history. We've seen candidates for presidential office bashing the federal courts. Newt Gingrich, for one, as you may recall, recently called for Congress to issue subpoenas to the justices so that they would show up in front of Congress and defend their judicial opinions before the legislature. President Obama took some heat a couple of years ago in his State of the Union for criticizing a Supreme Court opinion. Although, I think importantly for our discussion tonight, he did acknowledge that it was the law of the land, even though he disagreed with it. The blogs are pulsing with rantings of people who think that they know what the Constitution means and are not afraid to accuse all those who disagree with them of being unpatriotic or evil. And the comedians, like Stephen Colbert, have taken criticism of the court to a whole new level in our popular culture, right? So how all of this and much more should affect our understanding about how we think of constitutional law is the thing we're going to talk about tonight. We're going to examine the question in some detail. You'll hear our panelists set out their basic points of view, offering very different visions of what role the Supreme Court ought to play in our constitutional democracy. And then they're each going to speak briefly on laying out their positive views. Then we're going to try to get a little more nitty-gritty about specifics, and I will try to draw them down into perhaps with examples and follow-up questions to see if we can understand their points of view and what they have in common and what they do not, and then we will have questions from all of you afterwards. So first, let me turn the podium over to Dean Larry Kramer.
So thank you. It's true, the year we clerked together, I spent most of that year getting angrier and angrier.
He never stopped getting angry.
Justice Brennan actually had a reunion at the end of the year. He only had them like every 5 years, and he was 80 that year, so we didn't think that there would be another one. And there was, in fact, only one more. And I was so mad I could not spend another minute in the building. I didn't go to the reunion. So I stand here with a little trepidation. One of the things Rebecca left out in the introduction of Erwin. Erwin's a couple years older than me, but we both grew up in Chicago. He was also a famous state champion debater, like really famous. I was debated, not that famous, let me just say that. But he's also been a co-author of mine. Actually, we wrote a piece together early on. It was on the role of the federal courts, not on constitutional issues or judicial review. But it's interesting if I go back and think about it, although the article we agreed on most things, there's a couple of footnotes where we had to say, we don't quite agree on this, and they were all sort of on this point on the role of the federal court. So let me just lay out a couple of points to start. I have a slightly more difficult burden here in the sense that I think I'm fighting an uphill battle. That is to say, the conventional wisdom is not the view I will offer here. Now, one of the things that's interesting to me is when I was in law school, it was the other way around, and my con law teachers had to fight with the class to try and get us to accept the idea of judicial supremacy. Just that wasn't. Not that we had thought about it much, but our first instincts were the opposite. And today it is very much the other way around. My students all come in, and that's their back. And this change has taken place essentially over the course of our life. And one of the points that I'll make is it's actually a historical anomaly. So I start just with one simple proposition, which is we have created a system in which we say we are dedicated to basically to the notion of self-government. And then we say, so self-government except for the things that are really important. Right? Those things we have to leave to some little oligarchy of 9 people who were going to try and basically set up as what the founding generation would have recognized as monarchs, right? Lifetime monarchs, but nonetheless monarchs within their domain, and we're going to let them decide all those important things for us because we can't actually trust ourselves. So as I say, just starting out, that is a funny thing, and that's why we've had 30 years of constitutional theories trying to explain and justify it. Now, let me just say, I can't go into all the history here, but that was not the original understanding, not even close to it. This takes some time, but let me just, if you look at Federalist 10, James Madison at the end of Federalist 10, where he lays out the case for an extended republic, says, in the extended republic, we behold a Republican solution for the ills most incident to Republican government. And one of the things that's always interested me about that is that paper gets a lot of attention, a lot of focus. People always focus on that second part, the ills incident to Republican government, and everybody agrees that there are ills incident to them. And then judicial supremacy is offered as a solution to it. Nobody pays attention to that first Republican right? It's a Republican solution to the ills incident to Republican government, and judicial supremacy was not, would not have been, and was not actually when the argument emerged at the time, was radically rejected. Madison is actually looking at, as are all of the people in his generation, a different kind of solution. And the problem is, there are ills incident to Republican government, all those things we all know about, which is Democratic majorities are prone, perhaps, to react too quickly on the basis of passions and prejudices and do all sorts of evil things. So what do we do about that, right? And then you get the conventional wisdom today, which is Madison is anti-majoritarian and the Constitution is counter-majoritarian. And that actually is not the way they thought about it at all. That would have been to betray the whole point of the American Revolution that they had fought. So you had to find a majoritarian solution to the ills incident to majoritarian government. And it is actually in lots of places, but if you look at Federalist 10 and 51 and take them together, they lay out, the basic theory there. One of the interesting things nobody ever notices, if you read Federalist 51, which is the sort of paper for separation of powers and how the national government is going to be controlled within this constitutional scheme, courts aren't mentioned. They're not actually mentioned anywhere in those papers because they're not really part of the scheme. The idea was what we need to do is, of course, slow government, we enlarge the republic. That gives us the capacity to get a better leadership class that we count on, but we can't count on them because enlightened statesmen aren't always at the helm. So we complicate the republic, which means we have lots of voices and places where people can check each other, but they're all ultimately beholden to the same population in the large sense, and what we get out of that then is a deliberative process. Is it foolproof? Of course not. No process is, but it is the best Republican solution we can come up with to the ills incident to Republican government. Now, judicial review does emerge in the early days as another piece of this, but it is, and judicial supremacy actually emerges as an idea in the 1790s. It's decisively repudiated, first in the election of 1800, that's actually the central issue there, and then across American history. So you end up with the system, and this is the next point I want to spend a little time on. What is popular constitutionalism? So let me explain the way the idea works, because the way this debate always got framed, like when we were growing up, was you either favored judicial review or no judicial review, right? And judicial review has come to become synonymous with the idea of judicial supremacy. And the idea is actually there is a middle position there, which is a system of judicial review without judicial supremacy. Now, how would that work? The first thing to understand is that judicial review is a practice. Judicial supremacy is an ideology. It's an ideological overlay on top of judicial review, which says once the court rules, that is supposed to be the final and binding decision on everybody. Of course, the people can make new constitutional law. You can do it through amendment, or if you're Bruce Ackerman, you can do it some other ways. But making new constitutional law is a different proposition from interpreting existing constitutional law. And the Supreme Court has final interpretive authority, and once they've ruled, that's it. So what does that mean? That means you have two devices to change it, which is you can, three, I guess. You can amend the Constitution, which is, of course, nearly impossible to do. You can try and persuade them to change their minds. And you can, hope that they die or retire. You can replace them with people more to your liking, and that's it. And that's literally what judicial supremacy means. Of course, we can protest, but our protests are directed at the court to try and persuade them to change their mind until we can get better people in there. If you look across American history, when the framers, when the founding generation first confronted this, they had the same problem. Actually, I'm going too long, but let me just step aside very quickly and move ahead. If you look at the modern constitutions of Europe today, because they all face the same issue, the constitutions that came after World War II in all the conflict countries. So they all have judicial review. And in fact, it's one of the common arguments is, look, everybody embraces judicial review. They love it. It obviously works. Except they structure the judiciaries very, very differently. So in all of these constitutions, you have one, recognition that constitutional interpretation is a political act, which is why that court alone in the European systems are politically appointed. All the other courts are appointed, it's a civil service position. Two, they require supermajorities to get on the court so that we guarantee that you have to have people who appeal to both sides of the aisle, which is why I actually think this is the one place where filibuster makes sense, although it doesn't make much sense for ordinary legislation. Three, the justices serve, and this is the most important piece, limited and staggered terms. So you have a guarantee of a regular turnover, which means the court can never veer too far out. And fourth, they make their constitutions easier to amend. So with all of that, you have actually a form of structural control of the judiciary that we don't have. We don't have it because at the time our founders wrote Article 3, they never imagined anything remotely like what the judiciary has become today. They were thinking about individual cases and wanting to achieve a balance between independence and accountability that was heavy on the independent side, so that the president or legislature or king couldn't come in and say, you know, I don't care if he's innocent, I want him convicted, right? So the English history of independence made them say, let's make the judiciary very, very independent. But if you have a policy-making role, you are always looking to balance independence and accountability, and the modern European constitutions do that with their judiciaries in a way that ours does not. So what did they do in this country? Well, they had to piece together from the political tools that did exist. So what did Jefferson do when he confronted what, from his perspective, and correctly I think, was a runaway judiciary? They abolished some courts. They threatened not to enforce their judgments. They changed the procedural rules to make their lives miserable. Jackson threatens not to enforce the judgments. Lincoln doesn't enforce judgments. Presidents and Congresses have been packing the court forever, right? I mean, one of my favorite examples of this is Lincoln gets elected. They enlarge the court to give him a couple of appointments. Lincoln gets assassinated. They shrink the court so that Andrew Johnson won't get appointments. Grant gets elected. They enlarge the court again so Grant gets appointments, right? This is a common practice. They strip jurisdiction and so on. So those are the tools that have been used, and the acceptance of judicial supremacy is essentially the delegitimation of those tools, right? So in some sense, the way this would cash out today, ideally we would amend Article 3, but the simpler way to do it would be just to restore the devices that have been used historically in this country to provide the capability for pushback from the political branches. Now, the thing to understand, I usually get this, the look I see from a lot of lawyers, like, what? Strip jurisdiction, slash budgets, not enforce judgments? How can you put, that's not law, right? Well, I actually don't agree with that. As I say, first, the people who did this in American history, Jefferson, Jackson, Lincoln, the Reconstruction Congress, Teddy Roosevelt, and Franklin Roosevelt, not exactly a rogues gallery, right? So pedigree-wise, you know, and of course the point being, once the tools are available, you pretty much never need to use them, right? Because the court becomes conscious of its role. It doesn't disappear. The court has actually been an 800-pound gorilla in American politics, which is why the only presidents who have successfully deployed these tools are Jefferson, Jackson, Lincoln, Franklin Roosevelt, and Teddy Roosevelt. But it's out there, and it provides a different kind of dialogue. And of course, it is timed with the delegitimation of those tools that we've seen the Supreme Court grow enormously in its power. We've seen our ability to put anybody on the court who had ever said or done anything disappear, because now the court is so important. And we've seen the runaway power that we get from the court. So the last point I just want to make, to toss out to all of you to think about, is what is peculiar about this to me is if you look across American history, there was always this dialectic. The idea of judicial supremacy emerged in the 1790s. There's always been this fight about it, and it was always framed as progressives opposed the court, conservatives favored it. Conservatives favored judicial power, progressives favored what they could accomplish through democratic policymaking. And so what's peculiar is at some point in the 1960s, because of a weird historical blip, and it's a historical blip, that is the Warren Court, progressives flipped. Conservatives did not. They've never stopped embracing judicial authority. They simply don't like the way a progressive court interpreted the Constitution. But they're not acting hypocritically when they now say, you know, we have to enforce federalism, we have to enforce all the things that they've always held those positions. And so the weird thing to me is if you look historically, there was a reason for that, which is the court, from a progressive political perspective, the court has never been a friend, except for that one little period. And it so has imbued the imagination of liberals in the 2 generations since, because we didn't actually grow up, we're the next generation from the Warren Court, but that you know, if they toss an occasional bone, which is all they do, liberals continue to be the most vociferous defenders of the court, even as they eat away at every single thing you care about. They gut Section 5, they gut the Civil Rights Act, they're in the process of gutting the Voting Rights Act. I mean, you know, if they don't gut the Health Care Act, it's only going to be, it'll be because of the capriciousness of Tony Kennedy's mind. I mean, nobody knows how that one works. But it looks like they probably will, right? I mean, it's thing after thing, and so you get the occasional, you know, and whereas all of the gains, in truth, all of the serious gains that have ever been made for progressive causes from the beginning forward have come through politics. The legislation they're gutting is legislation that grew out of grassroots political movements. And so, you know, just from that perspective, it's always struck me as peculiar. We're not a little.
Dean Chemerinsky.
Thank you so much for coming tonight. I want to welcome some old dear friends to the law school. I've worked with Kara Stein for years. And Rebecca Brown and Larry Kramer, you're two of really the superstars in American academia, let alone in constitutional law. I was also going to talk about the article that Larry and I wrote together over 20 years ago. I still often assign it the first day of federal court because it really does lay out the questions of why have federal jurisdiction. So I'm so grateful to Kara and Rebecca and Larry for coming to the law school and for having this event. Tonight I want to defend the language of Marbury versus Madison. In 1803, Chief Justice John Marshall said, and I quote, "It is the province and duty of the judicial department to say what the law is." I want to make 2 points. First, I'm still unclear about what popular constitutionalism means. I've had the occasion of reading Larry's magnificent book, The People Themselves. It's beautifully written, it's well argued, but I finished it and I'm still wondering, what exactly does popular constitutionalism mean? We've been on other programs on the topic. We did one together at Berkeley several years ago before the book came out, and I asked the same question, and I remain as confused about it now as I've been all along. Now, what Larry told you is that popular constitutionalism is judicial review without judicial supremacy. I wrote down those words. But of course, no one wants to defend judicial supremacy. That's a loaded phrase. And besides, what does judicial supremacy mean? Now, if I understand this right, it's that the Supreme Court's decisions should not be final, that the ultimate say should rest people through their elected officials. And he gives you a few examples. He says, well, we'll allow Congress to strip federal court jurisdiction as a way of controlling outcomes. We'll allow Congress to cut the budget of the federal courts, or even to reduce the size of the federal courts to control outcomes. But I've never understood why he stops there. Why wouldn't he also support something that Robert Bork has argued for, allow Congress by a supermajority, or even a simple majority by legislation, to overrule a Supreme Court decision? Because if you really believe in not having judicial supremacy, not allowing the court to have the last word, then shouldn't we allow Congress to overrule it directly? Why only allow them to do it indirectly to things like jurisdiction stripping? But if you really believe in popular constitutionalism, why is this just about Congress? Why shouldn't a state legislature be able to overrule the Supreme Court if the Supreme Court is striking down a state law? If you really believe that the court shouldn't have the last word and people should have the last word, then state legislature should be able to do it. In fact, even a city council. If an Irvine ordinance or a Los Angeles ordinance gets struck down, why should the Supreme Court have the last word there? Why shouldn't the people of the city have the last word if you really believe we want to eliminate judicial supremacy? And why is this just about the United States Supreme Court? What about the lower federal courts? They are also unelected officials, so I assume if you're going to take popular constitutionalism seriously, if a federal district court strikes down a city ordinance or state law, the city council or state legislature should be overrule that as well. And if there's a distinction between the Supreme Court and the lower courts, or between Congress and the state legislature and the city councils, I don't find it in this book. And I don't find it in anything that Larry said to you tonight. Because if you really want to reject judicial supremacy, you have to say always the elected officials should be able to rule what the court's doing. This leads to my second point, and that's that popular constitutionalism is undesirable. And I want to give you 2 reasons here. The first is that enforcing the limits of the Constitution requires that the courts be able to have the last word, or at least the last word subject to a constitutional amendment, the ruling themselves. Here, too, I go back to the language from Marbury versus Madison. Chief Justice John Marshall explained that the reason why we need the power of judicial review is to enforce the limits of the Constitution. He said the limits of the Constitution being meaningless. There wasn't a branch of government to enforce them. I used to, and I haven't for a while, for the first day of constitutional law or federal courts, assign my students a copy of the United States Constitution and a copy of the Stalin-era Soviet Constitution. My students were always surprised to see that the Stalin-era Soviet Constitution had a far more elaborate statement of rights than the U.S. Constitution. And I would assign to them also a description of life in the gulags, usually something from Solzhenitsyn. And the question I'd always want to ask is, how can it be that the Soviet Constitution, with a much more elaborate statement of rights, had these abuses? And my answer has always been, it's because there was no court in the Soviet Union that could stop the government from the abuses. What makes our government different is that power exists. The problem with popular constitutionalism, relative to the limits of the Constitution, is that there's nobody then to check Congress and the president. They want to ignore the Constitution. There's no one there to check the state legislatures and the city councils. And what's left then of the limits in the Constitution? The second reason I think it's undesirable is that I believe the preeminent purpose of the Constitution is protecting minorities and the rights of minorities. The reality is that the majority generally doesn't need the court to protect it. The majority can rely on the political process. But it's minorities that can't rely on the political process. Minorities might be political minorities. They might be racial and ethnic minorities. They might be historically disadvantaged groups. As somebody who's argued many cases in federal courts of appeals, including the Supreme Court, on behalf of criminal defendants, I believe they are also a political minority. I would not want to rely on the political process to protect any of these groups. Imagine that the southern states could have exercised popular constitutionalism and simply said, we're going to ignore Brown versus Board of Education. I don't understand why, if we're going to have popular constitutionalism, the southern states couldn't have done that. And surely they would have. Or I think of the Supreme Court decisions that expanded the rights of criminal defendants. We know that Congress, in some instances, tried by statute to overrule these decisions. And we surely know that state legislatures have tried to do the same. And so to me, if we're going to really achieve the goal of protecting minorities, we need the court to be able to have the final say, at least absent an amendment or a decision. Now, Larry makes a few arguments that I want to respond to. He begins by saying that we've created a system of self-government, except for this unelected branch of government, the judiciary. I think he misdefines American democracy. We are not a pure democracy in this country. Democracy does not mean majority rule. We are a constitutional democracy, which means we give most choices to elected officials. Whether to go to war, the size of the budget deficit, most decisions government makes don't come before the court. But we do, in some areas, those governed by the Constitution, give the court the final word. I think it's wrong to say we've created a system of majority rule. We've created a constitutional democracy. Second, Larry makes an argument based on the original understanding and says that the framers didn't intend what we have now in terms of what he calls judicial supremacy. Well, I have two responses. One is we don't know, and the second is we shouldn't care. In terms of we don't know, there is no way to know what the framers thought with regard to judicial review. The Constitution is silent about judicial review. Nothing in terms of judicial review, as we know, was spoken of at the Constitutional Convention in Philadelphia in 1787. They rejected a council revision, but they didn't talk about judicial review. Maybe it's because they assumed that there would be judicial review. Maybe it's because they assumed there wouldn't be judicial review. But we don't know what the framers thought about this. We don't know what they thought about most questions. And even if we knew, I don't think we should care. I agree here, too, with what John Marshall said in McCulloch versus Maryland. We must never forget that it's the Constitution we're expounding. The Constitution meant to be adapted and endure for ages to come. The Constitution is a living document. Finally, he says foreign countries can have judicial review in a way that's different than ours. Now, to discuss the practice in foreign countries would take much more time than we have. I think the only fair thing to say is that constitutions and judicial review vary enormously across the world. There are countries with constitutions more elaborate than ours. There are countries without written constitutions. There are countries where the judiciary has the power of judicial review. Countries where the judiciary's never had that authority. Countries where there is judicial supremacy, countries without it. But I don't think now. Now, Larry says, if there were popular constitutionalism, we can expect that the branches of government would comply with the Constitution. Why assume that? Why assume that without judicial review, the branches of government wouldn't feel emboldened to ignore the Constitution and its limits? Finally, Larry says that progressives should be skeptical about judicial review because there's really only been one blip in American history, the Warren Court, where the Supreme Court took a progressive approach. And I think he makes a very powerful point. And here's the question we all have to think about with regard to judicial review. Are cases like Brown versus Board of Education and Roe versus Wade worth the costs of the cases like Dred Scott or Plessy versus Ferguson, or maybe the Supreme Court striking down the Affordable Care Act? To me, this is a very difficult question, because I believe that there were popular constitutionalism, Certainly the states would have overruled Brown and Rupp. And the question is, the benefits of those decisions worth the cost? My instinct is that the answer is yes. That we're better off as a society having an unelected branch of government protect and define our most cherished values. But I'll concede it's a matter of instinct. It's not something that can never be empirically proven.
You probably have
Say
things
a
you want
few
to say. I know,
things. This may take a while.
That's fine. Just do it.
I'll just touch on some of the main points, although, part of it is, I feel that thing where sometimes it's hard in politics, open political debate, where everybody, it's like you can't make a complicated point and everything gets simplistic, and I feel like I've just been trapped in one of those, because the point is that I'm trying to make is complicated. And so let me just touch on a couple points. First, Marbury, if you actually read it, honestly takes my position. That line is ripped out of context. So the argument the argument for judicial review went something like this. And this is the position I'll take. It's not pure democracy. It's not direct democracy. It's departmentalism, right? It's that we have branches of government that we set up to reflect popular views in different ways, and all of them have an equal right in the course of doing their ordinary business to say what the Constitution means. And none of them then, their say is, the say of none of them is superior to any of the others, and they're all subordinate to the community at large, which reacts to what they do, and that's how this works. And so the argument for judicial review when it first emerged was essentially, the argument against judicial review when it first emerged went something like this. The people have agents, legislators to make laws, executives to execute them, judges to adjudicate cases. And if there's a debate about whether the legislature, in doing its ordinary business, passing a law, violated the limits that the people put on it in the Constitution, that's between the legislature and the people. Courts have no business getting involved in it. It's kind of like I have a gardener and a cook, and the gardener keeps coming into the kitchen and telling the cook how to cook. It's not your job. If I don't like how the cook is cooking, I'll deal with it. So there shouldn't be judicial review. The answer to that, given at the time, was, well, no, but if in the ordinary course of adjudicating cases a question of the Constitution comes up, the court has to address it. It's not superior to the legislature's voice, and it's always reflected back to the people. Okay? The 18th century way of saying courts adjudicate cases is the courts say what the law is. So if you read that line in context, he's setting up the conventional argument for judicial review, which is and then his next line is, so if a law is inconsistent with the Constitution, we can't ignore it. That was in contradistinction to the argument for judicial supremacy, which already existed. And the interesting thing about Marbury is that argument was very well known at the time and was made in particular language in particular ways. And Marshall went out of his way to use none of that language, right? And so in the context, the reason Jefferson never said anything about this part of the opinion was because Marshall had rejected the Federalist argument for judicial supremacy and embraced the Jeffersonian argument. So it actually doesn't stand at all for what it's used for today. It's actually stood for exactly the opposite in context. I make that point because this is the single most misread line in the case in all of American constitutional law. On the theory, when Erwin's right, the book does a bad job laying it out. I didn't realize that at the time because it was kind of embedded in the history. For what it's worth, I did a follow-up article, which I will send you, which said, oh, from the reviews, it's clear nobody understood what the theory was. So here, let me lay it out here. I obviously can't go into it at length, but I want to just get you to understand this is the part that gets a little complicated, which is, so Erwin says, well, then why can't every officer just reject? Why can't Congress just overrule, decisions of the Supreme Court whenever they want? So the way I look at it is the following. Perhaps they could. And I say there's multiple ways in which to run what you're trying to do in government is balance independence and accountability. Nobody wants a directly responsive government. You have leadership and you have representation and you do all that to slow things down, get some expertise and so on. So you want all of your branches of government to be independent to some extent, but you also want them all to be accountable because it is supposed to be a system of self-government all the way down. And by the way, again, it's not that I'm saying original intent, I'm just noting that for the people who actually created this country, that was an ironclad rule. The whole point of the American Revolution was republicanism. The definition of republicanism was majority rule.
Could I just break you for a second? I'm not. You can keep
I'm
going.
almost done.
No, I want to hear, but I also want to say, because this is screaming the issue to me, which is you care deeply about the theory of self-government as the justification for your position. How can you call our representative legislatures?
You mean the current one we have now?
Or not today, but in it's hard to argue that Congress represents the exercise of self-government by us. You're talking about us, the people. So I thought, actually, when I read your book, you were talking about us hitting the streets with muskets and clubs, because that's real popular constitutionalism. So if you're going to limit it just to Congress
No, I don't.
or the executive branch or other institutions of elected government, then I think you really have to go back a step and say, how do those satisfy our theories of self-government?
Well, or what you have to say is, to the extent that there are problems there, the solution isn't to create an oligarch and a mini monarchy. The solution is to fix that problem. So across American history, the way our democratic institutions have worked and the extent to which they've worked has varied over time. But that's the problem then to address, and it can never be the solution to say, you know what, let's just give up on that, and we'll let 5 people about whom we're going to have no control, who get appointed when they're young now, and get to sit there forever, we're going to let them decide the important issues of our life. So that can't be the solution. So I totally agree, and I think now things are worse than ever, but that's what we need to address and fix. That was going to be the next book, by the way, which I won't be writing now because I just took another job. The thing, though, I just want to, let me just to get to is the following, which is there are many ways to cash that out. Many. Lots of possibilities. But what I have looked at and the way I've always understood constitutional law and still do is it's a form of customary law refracted through a text. So the way it has cashed out across American history, and I don't believe in original intent, except as the starting position and then trying to understand it, is through a departmental system, right? In which these have been the devices we used. If there were to be new devices, like should Congress just be able to flat out overrule, that itself would become part of the popular constitutionalism debate. The point I want you guys to understand is prior to about 1960, the system I'm defending was the system in this country. That's the point. How does popular constitutionalism work? Look at American history. So to me, Brown is the classic example of popular constitutionalism in action because it leaves room for judicial review. Judicial supremacy was not embraced by any stretch. Eisenhower went through a process, should I in fact go in and support, and decided to do so for lots of reasons, moral reasons, a sense that that's actually where a majority of the country was, and so on. The weird thing about Brown is that the opposition was regionally concentrated, but Brown and the opposition, the Southern governors, were not acting illegitimately, they were just wrong. That was part of the debate. The denouement of that was the Civil Rights Act of '64. Right, that's the point. It's like, no, it doesn't happen in the single. The Supreme Court didn't change anything. They were one part in a really complicated national debate over how we should think about race in American society. We're not done with it by any stretch. But that piece of it, right, that was a big part of what led to, and it was a part of a larger political movement in which the fact that the Supreme Court had said it was not the reason to do it, although it was because of the reasoning itself. And there was an ongoing national debate that took place over time. And that's, to me, is the best way to do this. That's what's missing in the Soviet system, is that they did not have the capacity to do that. And again, I just want to say, the idea that courts do not protect minorities. They have not, right? I mean, if you look at race, to take school, Brown was totally ineffective. You got no action until the grassroots political movement led you to the Civil Rights Act of '64, which gave the Department of Education power to pull funding from schools that didn't desegregate. And a whole lot of other political action took place. So to me, this is not a close question. It's not like, how do I balance Roe against Dredd? It's if you look across American history, the extent of the role's participation has been modest, and it doesn't go away with the system where you have judicial review. But what you have in the empowerment of the court that's taken place in the last 30 years is there's no pushback whatsoever. It's the ideological, it's Bush v. Gore comes out, and the next day Al Gore says, I think they're wrong, but it would be unpatriotic to oppose. In 1876, when the same thing happened, the Supreme Court was asked to get involved. They didn't, because they knew if they had tried something like that, the 49.9% of the country that disagreed with what they did would not have stood for it. So they didn't, and it got worked out politically. And my view would be that's the way to go.
So, yes, please.
Yeah.
I want to go back to the 2 points that I made. The first is that I still don't understand popular constitutionalism. And I confess that having listened to Larry tonight, I'm as confused as I was before. I still want to know, if you believe that the people are sovereign and the people are safe, should Congress be able to overrule a Supreme Court decision by majority vote? Should a state legislature be able to overrule a Supreme Court decision by majority vote?
Can I answer really quickly? I can answer it now.
Sure, go. And then,
which is they can try. And the question is, will they get support or not? And the answer from most of American history is not unless the Supreme Court has gone way out of line for a long time. So the answer is, see, what you're looking for a simple rule of recognition. This is the simple complex thing, and it's not. The point is constitutional politics, and it is all constitutional law, it's constitutional politics, and politics doesn't work by simple, clear, bright line rules. But the way it has worked, you get compliance most of the time. The court is, as I say, an 800-pound gorilla in American politics, and you can only mount this kind of resistance when, in fact, they have gone wildly against strong public views for a long period of time.
I think the reason it hasn't happened is that throughout American history, it's been thought that the court does get the final say when there's a disagreement.
Yeah, it has. That's what.
Let me talk for a couple of minutes and then you can talk. I think throughout American history, the reason Congress hasn't tried to overrule a Supreme Court decision by majority vote is Congress didn't think it had the authority to do so. The reason state legislatures don't disregard Supreme Court decisions is they don't think they have the authority to do so. The reason city councils don't do so is they don't think they can do so. And I don't know why we're just talking about the Supreme Court, why we're not talking about lower federal courts as well. In his conclusion to the book, Professor Kramer writes, and this is where I found his explanation of what popular constitutionalism is. In effect, though the analogy is more suggestive than literal, the Supreme Court justice would come to see themselves in relation to the public, somewhat as lower court judges now see themselves in relation to the court, responsible for interpreting the Constitution according to their best judgment, with an awareness there's a higher authority out there with power to overturn their decisions, and actual authority to, not some abstract people who spoke once 200 years ago and then disappeared. And so I read this as saying that we should interpret the Constitution to allow Congress or a state legislature or the city council to overrule what the Supreme Court has done. And he says prior to the 1960s, we followed this theory of popular constitutionalism. I don't think that's right at all. Think of the era from the 1890s to the 1930s, when the Supreme Court was regularly striking down federal, state, and local laws. 200 laws got struck down. Take one example. When the Supreme Court declared unconstitutional the federal child labor law in Hammer versus Dagenhart, the Supreme Court thought that the only way they could overrule that Supreme Court decision was by amending the Constitution. And they passed an amendment and sent it to the states, and it didn't get the 3/4 of the states. If Larry's view of popular constitutionalism was followed then, why would it take a constitutional amendment? Why couldn't Congress, by majority vote, just overrule the Supreme Court decision? Now, if his theory of popular constitutionalism stopped short of allowing the legislature to overrule a Supreme Court decision by majority vote, he's got to tell us what that line is and why he draws the line there. Now, the second point that I made was that popular constitutionalism is undesirable. First, I said that the limits of the Constitution require that the judiciary be there to enforce them, that we shouldn't trust the elected branches of government to comply voluntarily with the Constitution. And second, I said protecting minorities requires that the Constitution be enforced by the courts. And I think that's the preeminent role of it. And Larry said the courts have never succeeded in protecting minorities. I think that's a tremendous overstatement. I think guard the First Amendment cases, where the Supreme Court has often protected unpopular speech and unpopular speakers. You see an example of this. Larry and I have very different views about Brown versus Board of Education. I don't believe that the civil rights movement that followed in the 1950s and the 1960s, including the Civil Rights Act of 1964, would have ever happened without Brown versus Board of Education. And I don't believe that Southern elected state legislators or Congress would have ever done what the Supreme Court did in Brown versus Board of Education. Brown truly changed the world in a dramatic way. But that's just one of many examples. And had we left it to the southern states, if they thought they could overrule Brown in New York, they certainly would have done so. Finally, I just want to comment about our views on Marbury versus Madison. I don't think either of us would want to count the number of times we've taught Marbury versus Madison. So the number of times we've read Marbury versus Madison, we actually read it differently, which is interesting. I don't believe that statement is at all taken out of context. There's no doubt what he says is right in terms of departmentalism, that Marbury does accept the proposition that each branch of government can interpret the Constitution. In fact, John Marshall says that the court takes an oath of office. All elected officials take an oath of office to uphold the Constitution. But the question is, what if Congress and the court disagree with regard to whether a provision violates the Constitution? And here John Marshall says the limits of the Constitution would be meaningless unless the court had the power to strike that down. So I really believe when the court says it's the province and duty of the Judicial Department to say what the law is, they're also indicating that it's the court that would get the last word relative to Congress. Now, I accept any case can be read in multiple ways, but I think that Marbury versus Madison put us on the path that we're today. I think it's the path that's worked throughout American history.
Just two quickies.
Yeah.
So one, with respect to Marbury, I mean, again, you just have to go back and read it. It's helpful to read it in full context. Jefferson's position also was in favor of judicial review just without judicial supremacy. So his view was, yeah, the court has to do that while doing its job, but if I disagree, I don't have to follow it. And then the question of whether I will or will not and how people will react is itself part of the constitutional politics. It's how the people have their final say. So, the line used was a pertinacious adherence by each of the branches to its view would soon bring the matter to issue with the public at large. Now, the thing that's weird about this is I think Erwin's position presupposes that the court's view of the Constitution is right? Because he keeps saying, like, if the court's view isn't final, then the branches of government can just violate the Constitution. But as I look at it, in all of the controversies that ever happen, we're always actually choosing between two potentially plausible views. I mean, it's never the case that everybody agrees something is right except for, the legislature. The elites are always divided. The court is always divided over these complex issues. So we're really trying to choose between two potentially plausible interpretations of the Constitution in any real controversy. And that's why the question is, so whose view of that should prevail? And the question why the courts should is not immediately obvious. And then you come back to if our fundamental commitment is as it is, and I would want it to be, is to self-government, then it's really hard to justify taking those issues and giving them to the court when we have actually no reason to think the court is systematically right. Now on Brown, again, I just want to point, someone I know did a study, the role of Brown, trying to understand, like, how important was it? So suppose you wanted to test this proposition, was Brown a precondition for the civil rights movement and all that happened after it? I remember when he presented it to us, he said, so there's your social scientific concept. What would you look at? So people said, I know, I'd look at newspaper coverage. And he said, I did. There's like 3 weeks of coverage after Brown, and then it just disappears. I'd look at the speeches of the civil rights leader. He said, I did. They never mentioned Brown. I'd look at their diaries and their letters. He said, I did. They never mentioned Brown. In fact, Brown becomes Brown, he said, and he documented this, only actually in the late 1960s when it is resurrected as the civil rights movement turns violent. And people are trying to sort of justify this as something that can and should be done within, less violent legal means. So, I mean, it's pretty clear to me. I don't, by the way, go as far as he did to say that Brown was completely irrelevant. I don't think it was completely irrelevant. It was part of the larger atmosphere, but it's not what got Rosa Parks out there. It's not what got the Freedom Riders out there. They were looking at actual injustices on the streets in the places where they were living, and that was enough for them. And so Brown isn't irrelevant, but nor is it the thing that did it. And to me, the notion that but for the court we wouldn't have rights, oh my God, that is so scary, right? Because you can't count on the court being there. And as I say, the difference between the Soviet Union and us isn't the court. It's a political system and a political culture that is in fact fundamentally committed to these ideals, although there are strong disagreements at times and two plausible positions that some of us can disagree with, which is why I say if you're a progressive, the court's not going to be your friend in the long run in which position is going to prevail.
Well, yeah. Sure. Can I just say one quick thing before, which is just that I know Justice Marshall disagrees with you about, in the sense of, I actually once heard him talk about why, he brought the Brown case, he argued the Brown case, and as head of the NAACP made the strategic decision to bring a series of cases culminating in Brown, and he talked about why, and did you have some great vision that the Supreme Court was going to be the champion of your rights? And his answer was, of course, in typical Marshall way, very earthy, heck no. We tried everybody else and we failed. I practically got lynched when I tried the state legislatures. We tried the anti-lynching bill in Congress. That went nowhere. I tried to desegregate the military. That didn't happen until later in Truman. Congress wasn't helping us. The states weren't helping us. The executive branch wasn't helping us. We thought, what have we got to lose? Let's try the courts. So, I really think that his experience, which you might disagree with, of course, because he viewed Brown as an important case, but he would, of course. But of course he would. But I'm just saying that in terms of the genesis of Brown and the impact that was felt at the time was seen as an extremely important avenue because there were no other avenues.
Yeah, just, the thing about doing history, I've done a lot of history now, and the first thing you learn is the most unreliable reporters about history are the people who lived through something. So I've had so many occasions now where, like, I had this thing recently where I was talking to somebody, there's just a bio of Judge Friendly that came out, and when I interviewed the guy, I told him all about this clerkship and these experiences. He said, gosh, that's totally different than what you wrote the judge at the time, and he pulled out all these letters I'd written, and it was like, oh, you're right, they're all exactly the opposite of what I just said, and that's, so, what I thought was interesting about the research that's been done since Brown is when you go back and you look at the contemporaneous comments of the civil rights leaders and all the people who were behind and involved in the civil rights movement, Brown isn't there. It doesn't begin to appear until, as I said, the late 1960s. And then Brown becomes the Brown that it is today. Now, again, I don't want to say it's an unimportant case. It's not an unimportant case. It's just not the thing that gave us protection.
Let's go back to Erwin.
My basic position is that our society is better off with an institution that's largely insulated from majoritarian politics to define and protect our most cherished rights. That's why I believe that we should have a court there that has the power to interpret and enforce the Constitution. Now, we do have a very different perspective of Brown. I want to run to my office and get Richard Kluger's book, Simple Justice, because the most eloquent explanation in that book of why Brown versus Board of Education really made an enormous difference. And there is a linkage between Brown and the civil rights movement that followed, and the Civil Rights Acts of 1964, the Voting Rights Act of 1965. But it's not just Brown. We could talk, for example, about Roe versus Wade. In 1973, abortion was illegal in 46 states. I believe very deeply that women should have the right to choose. I don't believe the political process would have ever gotten us there. Or we could talk about malapportionment. State legislatures weren't going to reapportion themselves. If it wasn't for Baker versus Carr and Reynolds versus Sims, we would have, to this day, I think, malapportioned state legislators. Or the example I mentioned earlier, I think of the rights of criminal defendants. When is the last time that a legislature voted to expand the rights of criminal defendants or prisoners? If I was relying on the people for that, think of what rights people would give to criminal defendants and prisoners. In fact, there have been so many instances where Congress has tried to overrule Supreme Court decisions expanding the rights of criminal defendants. And it's here that I think we really need the court to be able to do this. I don't believe that but for the courts there would be no rights. That's certainly a caricature of my position. But I do believe that without the courts there would be less in the way of rights and less protection of rights. The courts at times do things that I really dislike. And the question is, how do I weigh that against the things that I've just listed that I like? I can't empirically prove that we're better off as a society. But when I think of Brown and Roe and Baker, Miranda, Knapp, and so many cases protecting the rights of criminal defendants, I'm glad that we as a society have an institution, largely insulated majority in politics, to define and protect our most cherished values.
So just for you guys to think about, again, all those cases are in that little blip, right? And the interesting thing to think about, again, I don't think the courts are relevant, by the way. I'm there. I think they can make a useful contribution at times, though I think most of those are bad examples. So, for instance, criminal defendants probably have fewer rights today than certainly they would have, in my view, had the Warren Court not pushed things so hard that you got this massive political backlash. And then, of course, when the court went back to normal, as it has been embracing all of that and eating away at all those rights. Whereas, in fact, in the period leading up to the 60s, right, the 40s, the 50s, all through that, there had been steady and progressive reforms of the criminal justice system coming out of politics. Lots of it. It all got killed, and it was all very much a product of backlash to the courts pushing things, to the death penalty being the most obvious one, right, that we're all sort of aware of. You're worse off now if you're sentenced to death, and the process by which you will get sentenced to death, than you were before Furman. Now, not to say the court has never done anything. I think Roe v. Wade is really complicated, right? There is this right on the books. On the ground, in huge portions of the country, women can't get abortions today, right? I mean, there are states where there are, in theory you have the right, there are no clinics that can or will operate. Wealthy women can fly somewhere else to get it done. Poor women can't because, of course, they're not allowed to support it with governments and so on. So all of this is just more complicated. But to me, what I look at is it's that period that has seen the expansion of the court's power to the point where they can decide a presidential election, and where everybody's waiting to see for them to tell us whether a 40-year fight for health care, whether we're going to be allowed to have it or not, right? And there will be acquiescence. That is a difference, right? That's a big difference. And the kind of pushback you get and the way the court anticipates and acts to the pushback. That's why it's not a simple position. It's not the legislature could or should or would overrule it. It's that it's part of a complex political dynamic in which we don't think that when the court speaks, that's supposed to end it all, but nor do we think that they're irrelevant and we ignore them. We take their arguments quite seriously, and they're part of a constitutional debate, and you know, that's the way it had worked until the last generation or so.
Do you want to say one more thing
Sure.
before we open it up to
And
questions?
I promise I will not say anything.
Oh, that's okay. I think Larry, in his last comments, wants to have it both ways. He wants to tell you, as he did, that he believes in judicial review. In fact, the conclusion of the book says he wants to have judicial review. But then what he's really saying now is, you know, judicial review is bad and unnecessary. It's bad because we'd have more rights for criminal defendants without it, and it really hasn't done anything with our abortion rights. That's an argument that we really should eliminate judicial review, not that we should have popular constitutionalism. And again, we disagree on the examples. I mean, there's no way to know what would the rights of criminal defendants been without the Warren Court. It's counterfactual, we can't know. But I think it's a far more complicated story than he suggests. And I think most led to the backlash with regard to rights of criminal defense was the increase in crime. And it was fear about crime that I think caused the desire to cut back on the rights of criminal defense. I don't think it was about what the Warren Court did as the primary cause. I also don't believe that criminal defendants would have more rights today without the Supreme Court. The reality is that state legislatures, Congress, aren't and never have advanced rights of criminal defendants and prisoners. That's a place where it's the court or it's nobody. With regard to abortion, again, we would just disagree. But half the states today have laws that will prohibit abortion if Roe versus Wade is overturned. Those laws will go into effect immediately. Michigan, for example, has a law that prohibits abortion, and the Michigan Supreme Court has ruled it will go into effect immediately if Roe is overturned. Half the women in this country will live immediately in states where there is not safe legal abortion. Now, he's right. In many states, there's only one or a few abortion providers. But that's still enormously different from a world where abortion would be criminal in about half the states. And I don't believe the political process would have ever brought us to what Roe versus Wade got us to in terms of protecting a woman's right to choose. And to me, this is why it's important that we do have an institution like the judiciary that can interpret the Constitution and protect minorities and their rights.
Okay, I mean, I think before I open it up, I want to ask one more question to Erwin, and then please have your questions ready. So think about whom you trust more with your rights and liberties, the people through their elected representatives, or perhaps en masse, or the courts. I mean, that's really in a way what it comes down to, or rather, whom do you mistrust less? But I just want to ask Erwin just to lay out, because he hasn't addressed it, what should we do when a constitutional decision by the Supreme Court a lot of people think is dramatically wrong, and perhaps so wrong that it actually undermines the very processes of the political government that we rely on for our self-government. For example, I'm speaking of Citizens United, undermines the integrity of our elected branches, which we are now being told, or we have to rely on, should be our first defense, right, in terms of making policy. What should we do? What can we do then when the court gets it terribly wrong?
And I'd be fascinated also to hear Larry's answer to that from the perspective of popular constitutionalism, because would he allow Congress by majority vote to overrule that decision? I think one of the things that we have to do is speak out against the decision and explain why the court is wrong. A second thing is the possibility of a constitutional amendment. Now, I think it's unlikely that the Constitution will be amended, but there are certainly proposals that are out there to overrule Citizens United by constitutional amendment. And third, we have to look forward to a change in the composition of the court. Citizens United, like all Supreme Court decisions, is entirely an artifact of historical accident. Imagine, for example, that either Al Gore or John Kerry had replaced William Rehnquist and Sandra Day O'Connor. Citizens United wouldn't have come out that way. Citizens United came out the way that it did because Samuel Alito replaced Sandra Day O'Connor, and the Supreme Court overruled the decision from 7 years earlier. Well, the lesson is that Democrats have to elect presidents and hope that vacancies occur on the Supreme Court. And if Democrats elect presidents and vacancies occur on the Supreme Court, Citizens United will be overruled in time. In that sense, if that's popular constitutionalism, I'm very much in favor of it because there is that popular control. But I think what Larry is arguing for, at least in the language of the book that I read to you, is something where there's much more direct control over the Supreme Court by Congress, and that's what I reject.
Do you want to speak to
No,
that?
I think Erwin just made my case, as far as I'm concerned, honestly. That is to say, if that's where we're left, we can wait for them to die or retire and hope we get the chance. And it's actually the accident, and it's more than an accident. I have this a slightly separate position, but my view is it is a political act of political immorality for any president. I don't care what party he or she is from, to appoint people to the court because they're young and they're hoping to extend their ability to control for generations. Right? It goes to what's wrong here. That is politically immoral. People should not be allowed to do it. And the notion then that, but we're going to be stuck with them. So again, my view is, it is politics as well as law. And it's not that the rule then becomes that Congress can overturn the Supreme Court. This is not the way it worked in American history. It is that Congress could try them. And there will be support for it or not, and that support will depend on how persuasive the court has managed to be in its position. And of course, what you can count on in our political system is there will be lots of people defending the court, lots of people criticizing the court, and we will have the kind of public deliberation that Madisonian democracy and American democracy is supposed to be about. And at the end of the day, a pertinacious adherence by the different branches to their positions will bring the thing to issue, and the public will support one branch or the other, and the losing branch will recede. That's what always happens. That's what always has happened in American history. So it's not neat, it's not pretty, and it's not certain. But then again, these are important issues, and neat, pretty, and certain isn't what we should be striving for.
Okay, great. Well, let's open it up to any questions that any of you might have for our panelists. Right here.
Well, I'll jump in because I'm glad Dean Chemerinsky talks about the impact on presidential elections, because that's kind of what we've become left with, certainly in the last 12 years. If you look at it with the presidential elections, a lot of time coming down to, well, who's going to be in a position to make an appointment to the Supreme Court? I mean, it's almost become a litmus test on who you're going to support for president, depending on who you like and your position. So if you're looking at judicial supremacy, it's almost become presidential supremacy, in that the final arbiter gets determined by who gets to decide who gets an appointment if somebody gets cancer and dies.
This isn't new. Richard Nixon ran against the Supreme Court in 1968 because of who left the court. He got 4 vacancies in the first 2 years. Jimmy Carter didn't get any vacancies in his 4 years as president. Had Alf Landon won the White House in 1936 instead of Franklin Roosevelt, it would be a very different court. So it's always been that way. Now, I'd support a proposal that said justice should serve for 18-year terms, and there should be a vacancy every 2 years, so we'd regularize vacancies so as to keep it less being a matter of accident. But where I'm still confused is what Larry's final comment was. Let's take Rebecca's example of Citizens United. Imagine that Congress were today to pass by majority vote, even though it's unthinkable, 2/3 vote, a bill that says Citizens United should be overruled, corporations cannot limits on corporate expenditures in election campaigns, what the Supreme Court struck down there. Does Larry's theory mean the Supreme Court can strike that down too? In which case I don't understand the difference from judicial supremacy. If the court can keep striking down federal laws, the court ultimately gets the last word. Or is it that the Congress gets the last word, and if the Congress wants to do it again, then popular sovereignty, the Congress wins? Either he's taking the former position, in which case we don't disagree, or he's taking the latter position, and in that case I don't understand why the Congress and the state legislatures can't overrule the court anytime they want.
Actually, he's taking both. So, which is to say, because I'll give you examples of each that's happened, which is they would do that. And then, if the decision was really unpopular, like Dred Scott, so Congress actually then proceeded to pass all sorts of laws just ignoring Dred Scott. And people went along. They actually enforced, and the Supreme Court knew better than to try and enforce and strike down those laws because it couldn't do it. It didn't have the support. On the other hand, after Brown, lots of states kept enacting laws. The court stuck to its views, kept striking them down. Eventually, they had to recede, although it was only after the political movement had risen to the point where you had the And so so as I say, what you're really talking about is it's a fight, right? Then the branches are holding to their views as long as they can, but they're engaged in an ongoing debate, and actually the public is settling it by how they treat. Now it's always the acts of the branch, and this is why it didn't have to go this way, but the way the devices emerged in American history for political pushback were not direct overruling, but were rather to take action against the court, like jurisdiction stripping or budget stripping, because that was a way to push back against the court and force the court to back down, but it's really, really hard to get away with that politically, which is why the vast majority of efforts like that from Congress failed. And one part where Erwin and I just disagree is my position is that the idea of judicial supremacy, while it was floating around, was not embraced or accepted until sometime it really begins to emerge in the early 60s, late 50s, out of the Brown litigation and other things, and is really only fully embraced slowly in popular political culture across the 70s and 80s. The Bork hearings, to me, are the reason they're interesting and important historically, is that's the flashpoint where we see what you're talking about has happened, right? Where people are going to say, who gets elected as the president is really important because that's who's going to put justices on the Supreme Court. In my view, is something has gone really wrong with your democracy when that's how people are thinking, and that's going to determine their votes. So, in the other system, it's actually who the president and the Congress are, because they'll keep pushing, and we'll see. We'll see. That's how politics works, just like it does with most constitutional issues that don't get resolved in the court. Remember, if you read through the Constitution, the vast majority of it never gets in front of the court. Not because there's never disagreements about it. It gets worked out. And the court just intervenes where it chooses to on the issues it thinks are important. And I'm okay with that. That's why I do want it both ways. But I just want the ability to push back, and not this notion that they've spoken, therefore what we have to do is wait for them to die or retire or hope that maybe they change their minds.
But you just said the court could keep striking down everything Congress does
until
the court makes.
They won't.
But we don't know, because we've never existed in the world.
No, we have. That's what I'm saying. We have for most of American history. This example has happened over and over again. Right?
Take the child labor cases then as an example, because the Congress would have overruled the child labor cases if it could. It tried, it passed a constitutional amendment. And it seems to me what you're saying is that you will accept judicial supremacy, but the hope is that if you can embolden Congress, the court will back down.
Actually, the progressive era is a great example, because it's not just the child labor case, right? There's, as you said, there are hundreds of laws being passed. The court strikes down some, most of them it actually leaves standing. But there's lots of pushback. Lots of actually states keep reenacting those laws, and the court backs off on most of them. The really interesting thing to me, and I have discussed this in my classes, I haven't written on this yet, is if you look across the progressive era, actually child labor is the only federal program that had substantial support that the court didn't back off on. And it's peculiar to me both why they didn't, particularly since if you read the personal papers of the justices, they're actually deeply troubled. Even Day is like really upset that he feels he has to strike, it's the tax law that they came back with the second time down. But they did it. I'm not sure, again, but the vast majority of the debates that they had actually, so a couple were done by constitutional amendments, the legal tender and the income tax. Others were done just by coming back and doing it in a slightly different version, or just doing it again. And then a couple the court got away with. And there's a really long period of uncertainty that really only gets resolved in the New Deal. I always teach that by saying, think of it this way: the court and the regulatory state are dating from about 1870 to about 1930. So the court's not saying yes, it's not saying no, it's letting most of what Congress does go ahead, but every once in a while it's striking something down, but it hasn't pushed things to the point where you get this real political clash. The New Deal comes along, that's like the regulatory state saying, let's get married. The court kind of panics, backs up to all the most conservative lines in its jurisprudence, strikes down a whole bunch of laws. A couple years go by, a little more time to persuade. They say, okay, let's get married. And so it took that long for things to come to a head. But the child labor cases are only one in a whole slew.
In one sentence, I think you tremendously underestimate the Lochner. 200 laws got struck down during their year. I don't think it was dating. Right. I think it was a rejection.
The 200 laws, it's not the 200 individual acts, but most of them are state laws, and most of them were struck down by a single, you have one decision that knocked out 20 laws. And a number of those states would actually just come back and reenact those laws. So it's a much more complicated story. It's not that they struck down 200, and certainly not 200 federal statutes. They struck down no more than a tiny handful of federal statutes. And that's where the aggregation takes place typically, is at the federal level. Because at the state level, the most people are going to get upset are people in that one state. And that's usually not enough to put together a national movement unless you get this really focused opposition, as you did sometimes in the South, around issues involving race. or slavery in the 19th century.
In the back.
So when the New Deal legislation was being struck down, Roosevelt tried to pack the court, and it failed. And so why did that effort fail? And based on what you mentioned before, how Teddy Roosevelt worked with Teddy Roosevelt, Abraham Lincoln, what was different about that effort to try to use procedural means to change the court and overturn the court?
So court packing didn't fail. In fact, it succeeded 100%. So let me explain why. So first, you can't look at court packing alone. It didn't come out of the blue as if Roosevelt had not said anything and then one day popped up with court packing. There had been steady pressure building from the administration against what the court was doing for the couple of years leading up to that. Roosevelt proposed the court packing plan. Now, there's this whole dispute about when the court voted to overturn in Jones and Laughlin, and they probably voted to overturn before, but that's because all the pressure was already there. In any event, once they overturned, and I think it's Sutherland who retires, one of the four retires and is replaced by Black, there's no need to continue to push the court packing, so he lets it die. There were also some political factors, but he'd gotten what he wanted, which is the court had actually reversed itself. No, Robert changed the one of them retires and it's put on the court. It's a combination of those two things that make Roosevelt so, and his, the leader for it in the Congress dies on him, but he doesn't need to push it anymore. So he actually succeeded if you view that plan as part of a larger pressure that had been put on progressively and that the court actually did yield to.
I think what that leaves out, there's a wonderful new book by Jeff Schisall that tells in great detail the story of court packing. And what comes through so clearly in that book was the strong opposition to the court packing plan. And Roosevelt was even told that it wasn't going to get through. And I think the interesting question is why Roosevelt even won a landslide in 1936 over Alf Landon. Democrats were supermajority in both houses of Congress. Why were they then opposed to court packing? And so, Larry's right, the court shift, maybe it was response to court packing, maybe it wasn't. We'll never know the answer to that question. Roosevelt gets to appoint people and court packing becomes unnecessary. But why even in early 1937, before it was known that the court was going to shift course, was there such intense opposition to court packing? And it was phrased then in terms of the independence of the judiciary. And so I think there is something that is very important about the judiciary in the way I'm describing it that's left out in Larry's description.
So I'll just, I agree, although to me the interesting question is what would have happened if they hadn't switched, right? What would have happened then, because would Roosevelt have continued to actually gain support? Would some of the opposition have yielded, and then people would have been, you're right, it's never going to stop. And the reason I pose the question that way is if you go back and you look at the other controversies, say when Jefferson pushed the repeal of the 1801 Judiciary Act, the opposition was exactly as strong. The debate took place in very much the same language. What's so interesting about Jefferson is it was Marbury that led Jefferson, who was thinking maybe I will just back off on this. At that point, it was a combination of Marbury being filed and Marshall not dismissing the case out of hand because it was frivolous on the merits, which, by the way, it was. And the new D.C. Circuit swears out a libel prosecution against a Republican newspaper editor that led Jefferson to say, they're not going to stop. I'm not going to give it up. And so the combination of the court sticking to its guns led him to stick to it, and he won eventually. To my mind, it's the security I have. The reason I'm not afraid that we devolve into the Soviet Union is, as I say, it's really hard. People in this country do understand and appreciate the role the court plays. I do as well, right? So it's hard to build up the kind of political opposition necessary. So the Roosevelt, even in 1936, was having trouble. My belief, which of course I could never prove one way or the other, would be had the switch not taken place and had they continued to strike down the New Deal, Roosevelt's position would have continued to grow in popularity and he would have gotten his court packing plan through. He made it particularly bad, by the way, of course, by also doing it disingenuously, and he was advised not to. That was just a stupid political move. He made it harder.
But a lot of the rhetoric on the opposition had to do with words like tyranny, which I think is very interesting for your point of view, that there was at least some voice that said having the executive branch take control over the supposedly independent judiciary is a descent toward tyranny.
Yeah, and the Roosevelt people are making exactly the same point on the opposite side, right? Which is, no, actually the tyranny is the court taking this kind of control and striking down laws that have huge popular support of the people at large. It's always framed that way, right? I mean, that's the point, you know. And of course, one of the interesting.
Well, except this isn't 1960. This is 1936, and this is really.
And it was framed that way in
and it was a
1803
big- right.
and in 1856 and in 1832 when they
There's a
had the
very
debate over
strong
the ban.
sense in all those situations that there is
There is.
an important value to having allowing the court to remain apolitical. Right? That's
Yes,
the
and it's when the court stops being apolitical, which of course it wasn't being and isn't being today,
Well, okay.
that you want to
Different
be able to
kind of
push
people.
back, right?
Different kind, but yeah.
I don't see it so different. It's straight. What's going? You've all heard those healthcare debates. I mean, does anybody seriously believe that this is anything other than straight ideology? Right? I mean, come on. I mean, let's not kid ourselves. The arguments, I think the argument against the Health Care Act, honestly, is sanctionably frivolous. Sanctionably so. You know, it's preposterous that anybody's taking this seriously, and why are they? Because they don't like Obama.
More questions? Yes.
How would block review affect rulings in our country, you know, similar to how Europe can have block review? How would that affect our political environment?
How would what?
Block review.
I don't know.
What's block review?
I believe it's a form of judicial review where they can rule on multiple cases, and kind of like an edict. It's in Europe, I think. I'm not sure if the name is correct or not.
Only because I used to, it's embarrassing, I used to teach a course in comparative constitutional law, and we looked at Italy, Germany, France, and Spain, and I don't think I even counted that. They can do review before laws go into effect.
Right, that's what I'm talking about.
Oh, okay. Oh, I see.
block.
Not taking blocks of cases, it's,
Yeah.
yeah, okay. Right, it's if we
Yeah.
didn't have the standing rules, so.
Right. Advisory opinions.
Advisory.
Yeah. Well, of course, they're not advisory if they're authorized that way, right? I don't know, Erwin, what do you think? This is not one that cuts strongly, I think, on either of our positions.
I'm trying to think about what it would be under popular constitutionalism. Imagine that the Congress says, we're considering this law. And the court says, if you adopt it, we're going to declare it unconstitutional. And that's what I understand you're saying, if they could give advisory opinions. Now, I understand in popular constitutionalism, Congress could then adopt it anyway. The court would then say, we told you, it's unconstitutional, it's invalid. And as I understand popular constitutionalism, Congress can adopt it again. And the court can say, it's still unconstitutional. And so the court really has judicial supremacy until the court, no, let me finish my sentence. Because the court can keep saying it's unconstitutional. All you're saying is, well, at some point, maybe the court will back down, or Congress can do other things to the court, like strip its jurisdiction to make sure it doesn't hear that bill again, or cut the budget of the court, or something like that, and use those kinds of tools. And of course, then you get to exactly our debate, where I think it's undesirable to say that the court could say to the Supreme Court and the lower courts, you can't hear abortion cases anymore, or you can't hear challenge to school prayer cases anymore. Or take your example of advisory opinions. If I understand what Larry's saying is, imagine that Congress comes to the court and says, we want to adopt this law. What do you think? And if there wasn't a prohibition against advisory opinions, the court could say, we think it's unconstitutional. So that if I understand Larry's position, what he just said is, Congress could then pass the exact same bill, but strip the jurisdiction of the lower federal courts and the Supreme Court and say, we adopt this bill, but you, the lower federal court and the Supreme Court, cannot consider the constitutionality of that bill.
Yep, I think they can, and I think they should be.
And that's where we fundamentally disagree.
So just a couple thoughts. So first, I don't think, the one thing, I think advisory opinions or not doesn't, let's say before or after, doesn't affect anything about my position, or I think Erwin's, usually the arguments for and against advisory opinions have to do more with, you know, how important is it that the court be able to see what it really looks like before they actually get into making these decisions. So I don't think it cuts one way or the other on that. But, you know, again, yes, the point is that the way to understand this, again, is how does politics work? So politics is always an equilibrium. It's a dynamic. So even in a system of total judicial supremacy, as I think, you know, Erwin was recognized at the beginning, there is a point too far where actually people will not stand for it. They'll do something. Right? The function of judicial supremacy, that's why I call it an ideology on top of a practice, is to take that tipping point and shove it as far as possible in favor of the court's authority. But it's never sort of an act that's done willy-nilly, and once you know where the equilibrium point is, the court is nothing if not a politically sensitive institution, always has been. So that kind of thing that you're talking, once we know that it can happen, it almost never will. And instead, what you have is the equilibrium point moved so that the court is taking into account, this is what I meant in that last paragraph, you're taking into account their sense of what everybody else thinks about the Constitution. I did a talk this summer with Justice Breyer, and he laid it out as, from his perspective, the biggest judicial virtue that he had was that he didn't care what everybody else thought. That he knew he was being a good judge when he would render a decision that he knew everybody hated. And I just thought to myself, again, if it were so bright line clear that you were right and everybody was wrong, there might be something to that. But on really hard issues where both positions are actually really plausible, do you really want a system where it's regarded as a judicial virtue that you don't care what everybody else thinks is the right thing to do? That can't be right. Now, Erwin, I hope will say, well, they don't, most of them don't really do that. They are taking into account, as I say, it's a matter of degree.
No, but I actually think the last exchange may be the most important of the because what you just said, if I understand it, is it would be permissible for Congress to pass a bill and at the same time strip the authority of the courts to be able to hear that. And you believe such jurisdiction stripping would be constitutional.
Yes.
And I would say then the limits of the Constitution are meaningless. Because then Congress
Because
at
you
any
define the
time...
limits
No,
of
let
the
me just... No,
Constitution
no,
is what the court
no,
says.
let me finish. What that then means is that Congress could adopt any law it wants, however blatantly unconstitutional, and say that the courts can't review this, and you said that jurisdiction stripping is constitutional. What's the limits of the Constitution? Who's the umpire to declare what Congress is doing unconstitutional? If there were a conservative majority in Congress who wanted to overrule Roe, they could then pass a law saying, Roe versus Wade is hereby overruled. We use our interstate commerce power to rid all abortions, and no federal court can hear a constitutional challenge to this.
So just two quick points. So one is take that exact sentence, substitute court wherever he said Congress, and I think you've said the same thing. The normal comeback will be something like, yeah, but the court can only act after Congress has acted, but of course one of the things that we see is that's not actually true. They can reach out in all sorts of ways and act aggressively, proactively to get rid of legislation all the time, and they do that. That was the point of the Lochner era. You had a lot of good stuff. So yeah, the question is who's the umpire, and I think the answer is that's why us. And the only way we have been able to cash out us, this is the Madisonian system, is to say all of the branches are agents of us in different ways. They all act. That's why I'm not in favor of referenda. I'm not in favor of mobs in the streets, except as ways to produce political action out of the branches, and that's how we decide. So these things, the reason they don't happen is because the fundamentals of the American political system until recently have been really solid, and they allowed this kind of debate to proceed so that it was really rare that you got these situations like one we're facing now, and the acceptance of judicial supremacy is what's upset the balance. Now, just one last point which I would want to make. This argument, I will confess, has gotten harder for me to make since I wrote the book, right, which was in 2004, and that's because I do believe that we have gone through a series of things that have happened in the political system which have really undermined the ability of our system to function properly. The point Rebecca was making, it's never been perfect. I always tell my students, if somebody gives you a theory of democracy that has actually never been realized anywhere in practice, there's probably something wrong with the theory. And this isn't a good place for ideal theory, but there's deeper problems now than there's ever been. But to me, the answer can't be, therefore, let's have judicial supremacy, or then why not just give it all over? It's got to be, we have to go back and fix some of those things.
Can I disagree even with that? I don't deny that the political system right now is dysfunctional. It's going to happen any time you have even one House of Congress of a different party than the president. I think because of many things it is particular. Is it the worst in American history? No. In the 1950s, Southern Democrats successfully filibustered every effort, except for one small exception, with regard to civil rights litigation, legislation. I think of what occurred in the late 1940s and early 1950s, the ugliness of the McCarthy era, and how deeply divided the country was then. We can go back through American history, even talking in the years before the Civil War. So I always worry when anybody says, things used to be so much better than they are now. You know, there were lots of times in American history when our country was, where our political process was dysfunctional and our country was deeply ideologically divided. I think this is a very poisonous time. I think it's a very dysfunctional time, but I don't think it's the worst in American history.
So, I usually agree with. I'm also adamantly opposed to golden ageism. I just think it's stupid. It's like it's been downhill since Aristotle. I mean, the slope is not that long. But what I'm focusing on when I make those claims is not the partisanship and poisonousness. Actually, those are a byproduct. But the way to understand democracy, as we've said along, has a potential tendency to spin out to the extremes. That's built in. So what is actually prevented in America, and why we're not the Soviet Union, has been a series of institutions whose function was to moderate, and they weren't designed. They actually just emerged. We got lucky in lots of ways. And they included such things as, a particular way of financing election campaigns, which has changed over time, but bore some similarities until recently. A particular way of dividing political power, that is to say, districting. There were lots of problems with it in American history, but it's different now. A particular form of political organization. We had political parties that worked differently over but are now completely broken. A particular kind of media that had a tendency to provide some set of reliable facts that people could use. And each of those institutions has been broken at different times in American history. So when people say, look at the press in the Jacksonian era, God, it was way worse, which is true. But they've never all been broken at once. And what I view us as, when I look at this, I think basically since about the late 1980s, we've been progressively getting worse. And so, like, this Congress actually put the Eisenhower Congress to shame in its ability to do nothing. And it's an order of magnitude less legislation than that one. But even that's just one symptom. And I'm puzzled now about where to begin to rebuild, because we used to have the others from which we could fix things. And right now it is a little scary out here, I think.
Is that a good point on which to end? I think it is. Thank you all so much for being here. Thank you.